As a franchisee, you might sometimes wonder about the fine print of your agreement, especially when it comes to performance expectations. It is natural to feel a bit of pressure when thinking about sales targets and what happens if you do not quite hit them. Is missing a sales goal just a setback, or could it lead to more serious consequences for your business? Generally speaking, not meeting sales quotas absolutely can be considered a breach of contract, but this outcome is entirely dependent on the specific language within your franchise agreement. The franchise agreement is a legally binding document that outlines all responsibilities and expectations for both the franchisee and the franchisor. The core reason this is not a simple yes or no answer lies in the detailed clauses of that agreement. A robust franchise agreement will explicitly define what constitutes a sales quota, how it is calculated, and under what circumstances failure to meet it becomes a breach. Key factors include whether the quotas are clearly quantifiable, if they are deemed a material term of the contract, and if there is a provision for a cure period. This cure period would grant you a specific timeframe to remedy the underperformance before the franchisor can pursue termination or other penalties. Many agreements also include best efforts clauses, which, while less precise, still obligate you to actively work towards the targets. To navigate this successfully, the first critical step is to thoroughly review your franchise agreement with an experienced franchise attorney. Understand every clause related to performance, sales targets, and default provisions. Proactive communication with your franchisor is also vital. If you foresee or are experiencing performance challenges, engage with them early to discuss strategies or potential adjustments. It is also important to maintain meticulous records of your marketing efforts, operational challenges, and any external factors impacting your sales, as this documentation can be crucial if a dispute arises. An important nuance to grasp is that many franchise agreements, while legally stringent, are also structured to foster a long-term partnership. Franchisors often prefer to work with struggling franchisees to improve performance rather than terminating the agreement, as finding and training a new franchisee can be costly and disruptive. The principle of good faith and fair dealing is implicitly understood in many contracts, meaning both parties are expected to act honestly and reasonably. Furthermore, understanding the initial performance projections in your franchise disclosure document, or FDD, can provide a baseline for what was expected when you first invested. Ultimately, protecting your investment and ensuring the longevity of your franchise unit comes down to a deep understanding of your contractual obligations and consistent, transparent engagement with your franchisor. Being well informed about the specifics of your agreement and prepared to address challenges constructively will put you in the strongest position to manage performance expectations and sustain your business.